Hello, coming to you live from Toronto, Canada. This is Acacia Thornton, the CEO Legal Coach, and we are talking about terminating an NDA, the action steps you need to take for success, and this is for business owners. We're going to go step by step through a number of things, and because this one might be a little bit longer, because I want to be thorough in the information I'm giving to you, we want to make this a practical step-by-step and information webinar for all of you. And then, of course, at the end, we will have a live Q&A. So if you have any questions along this way, keep them and we'll put them into the chat and I will get to them. Now, what are we going to go through today? We, of course, are going to first walk through what are the ways that you can terminate a non-disclosure agreement. Then we're going to look at the exact action steps and documents you might want to have on hand for those step by step for each of the ones that we're going to look at. And then a look at the continuing obligations, because ending the NDA usually doesn't mean what most business owners think it does. Sometimes it means an obligation for you, sometimes it means an obligation for the other side, and there's other things to consider, particularly when it comes to risk. So we're going to go through all this step by step. I'll even show you some documents, what to look for in them to get you along the way. And at the end, I'm also going to walk you through some of the resources on where you can find a lot of this information if you need it. Now, again, as always, this is for business owners. This is not about being a lawyer. This is not about legal stuff. Everything I'm going to walk you through today, you do not need to be a lawyer or have any type of legal background to do or take action on for your business. You can do these as yourself, as the business owner, as a representative of your business. You are able to take action on all of these. But again, there's always help for you. There's me as a legal coach, there's law firms out there, and I'll show you some of the other online resources you can use and have at your fingertips if you want to choose a different route. Okay, who am I? My name is Acacia Thornton. I am the CEO Legal Coach, longtime licensed attorney. I've been a licensed attorney for small businesses. I've also been a global senior counsel for Fortune 500s. I'm an award-winning sales rep for Fortune 500s and small companies. I'm also a business coach and consultant. And what this means is I have seen this from every side. I know what it's like as the salesperson trying to get this in with the customers. I know what it's like as the attorney trying to get this in for my clients and the corporations that I represent. And I know how it impacts your business. So this is going to be a really big perspective shift as we go through this, because today, again, is not about learning the law. No, practical. Practical. What do you need to know? What do you need to do? Let's get this done. Now, first and foremost, in case you're not familiar with what an NDA is, an NDA stands for non-disclosure agreement. It's a type of confidentiality agreement. In fact, it's the most popular, most commonly used in business. It is free to use, free to have. And what it does is it's a signed document saying that a party is not going to disclose the information they're going to get from the other side, and they're not going to misuse that information. There's a few different types of NDAs. They're usually either mutual, meaning both parties can share the information and both parties are going to protect it and both parties are not going to misuse it. Other times it's just one-sided. One party is sharing the information and the other party is the one making their promises not to disclose or misuse. A great example of that is an employee-employer NDA, right? The employer, the company, is the one disclosing the information to the employee. It's the employee who is promising not to share that information and not to misuse it. So those are the two ways. It's either mutual, everyone's doing the exact same thing, or it's one side sharing the information and the other side is promising to protect it. And that's really the only area that NDAs protect or impact things. NDAs are not about the customer agreement. They're not about the supplier agreement. There's no money exchange. It really is that simple. The information being protected from misuse and from sharing. And so when we look at that in that simplified context, we can look at a few different ways to terminate it. The three primary categories of a method of termination is, first and foremost, both parties can agree, right? A contract is both parties signing something, and an NDA would have both parties signing it. And so both parties can decide we just want to end it. That's totally cool. We would normally call that termination by mutual consent because both parties are consenting to that termination. So that's one of the routes we'll look at today. Another one we'll look at is expiration. Now, expiration doesn't need a process because expiration simply means the contract has run its course. If it was an NDA with a term of 3 years, well, at the end of those 3 years, it expires. Nothing to do, no action steps to take in order to terminate it because it terminates just by age, by having happened. So that's the second one is expiration, just naturally expires, hits the date of its term. And the last one, and this is where we're going to have more mutual action steps, and that's termination. Termination is an active method or process to end the contract early by one party. So the first one, mutual consent, is both parties are agreeing. Expiration is it naturally happens in time, but a termination is usually one party saying, I'm going to end this early. And these are the steps I'm going to take. So we're going to spend a little bit more time on that one because that's one where there's more action involved. So, mutual consent, what are the action steps if that's the way you wanted to do it? Let's say mutual consent means both parties, both signatories to the NDA are saying, hey, yeah, let's just go ahead and end this thing. What's great here is there's not going to be any contention, there's no concerns, because what you're going to do is create an amendment document, an amendment to that NDA, and the NDA that is going to now be terminated on this date, whatever date you choose. And so you're going to call out in that amendment which NDA, just in case you have others with other people or even with this company or person. You're going to say, hey, we now agree that this is the new termination date. This is the date it's going to be over. And then in case there's anything extra that you might want in there, like certificates of return or destruction, which we'll get to a bit later. But just knowing that you could always add something else. Now that it's over, these are what the parties promised to do or not do. You can throw those in there as well, but that part is totally optional. To terminate by mutual consent, you simply need an amendment document saying which NDA, the date of the termination for that NDA now, and then both parties sign. Once both parties sign, there it is, the date you have chosen on it. That is the new end date of your NDA. Now, an amendment is a very simple document. It's a document that is used to change any contract, any signed contract uses an amendment as its core document to make those changes. And I have a program called Happily Ever After, NDA Happily Ever After, but it's going to have an amendment in there with all the stuff preset for you. But if you don't have that or already have your own amendment document, you can totally use that as well. And it's that simple. Call out who the parties are, which NDA, the new date of termination. If you want extras, throw them in. If you don't worry. And both parties sign, and voila, your NDA is now terminated by mutual consent. Action steps for termination. Okay, now this is the one we're going to dive into more. I'm going to show you some sample NDAs, what to look for specifically. And this is the termination where one party is saying to the other, I'm terminating the NDA early. So this is where we're really going to spend our time. One side tells the other, we're terminating the NDA early. So first and foremost, it is important to know if you can terminate it once a contract is signed, because it is optional to enter into any contract with any terms. Once you're in the contract, it was then your option to whether or not you wanted to put anything in there where you can terminate it or end it early. So you're going to need to look into the terms of the NDA itself to know if you can have termination. Now, a general rule of thumb is that if it's your information being disclosed or protected under the NDA, a good template would give you the right to terminate. So, an example would be if you're giving your information to your employees, your information is the one being shared. So, it would make sense for you to have the right to terminate because it's about your information. But if it's not your information, it is very unlikely you have the right to terminate. Not impossible, but unlikely. And using that employee employer situation, it's not fair that the employee gets all the company information, has access to that, gets to use it for their employment, and then they get to decide when they don't want to protect it anymore. That's why it's usually whoever owns the information, whoever the disclosure discloser is the one who usually has the right to terminate. It doesn't make sense for the recipient side to terminate about information that's not theirs. Now, we did mention earlier there is mutual NDAs. And mutual NDAs are what I always advise in business relationships other than the employee employer. So, whether it's with your customers, your vendors, your suppliers, investors, partners, I always recommend a mutual NDA because both parties are promising to keep both parties' information secret. And that's great because when you have a business relationship, both parties are building trust and sharing information at some point in time. And so a mutual NDA, because it's both parties' information that can be shared and protected under it, whether or not you do in fact share is a totally different question. But because of the contract, the NDA protects both parties usually have the right to terminate. So let's take a quick look at an example here. I'm going to share my screen with you, and you are all going to be like, what is she doing? But I'm doing it. So here's an example of a mutual NDA. So when you are looking for whether or not your NDA says you can or cannot terminate, you're going to want to look for the term and termination section. It usually has this title, but the title might be just term. Or maybe you need to control F and skim or search for the word termination or terminate. It's almost always going to be one of those words. And it will tell you if you can or cannot terminate. So the term of this agreement, okay, provided that either party may terminate this agreement at any time. Awesome. Either party here can terminate at any time by doing what? By providing written notice to the other party. Cool. Now the NDA is saying, yes, you have the right. Either party here has the right to terminate. They may terminate at any point in time. And what they need to do is give written notice to the other. Cool. Awesome. Let's look at another example. I give away a free mutual non-disclosure agreement template, by the way, for everybody. Always available on my website if you ever need one. And that's what we're looking at right here. And its section is under term. So this one doesn't say term and termination, just says term. But by looking for that word or searching for the word terminate, guess what? We find what we're looking for. Unless earlier terminated by either party. Okay, so either party may terminate this one by doing what? With written notice to the other party. Cool. No timeline either on this one. Both of these NDA examples can be canceled by either person at any point in time by simply giving written notice to the other. Okay, so what is that written notice? Let's go back up here for a sec. And the notice of termination. So we've confirmed in our NDA by looking for the term and termination words. By doing that, it says that either party, so it doesn't matter which party, if it says one party or the other, confirm if you are that party. See if there's any requirements like a timeline or if it can be done at any time. And then what do you need to do? Written notice. Okay, so and that would be our next step here, notice of termination. So that we've confirmed we can terminate. Now we can go on to giving that notice of termination. Okay, a notice is a letter. It is a letter simply saying, I am going to terminate this NDA effective this date and any extras. So very similar to what we did in the amendment, but unlike the amendment, this one is not for both parties. This is not changing the NDA. This is taking an action step on the right that we just found in the terms of that NDA. The NDA said we can terminate at any time with written notice. That means you have the right to do that at any time with written notice. Here is that written notice. So it's called a notice of termination, and it's going to state that this NDA, called out by name and date, shall be terminated on the termination date you choose, and then any extras you might want, which again, we'll get into those in a bit. So same contents of the amendment, very similarly, but instead of being an amendment, we are not changing the document. We are taking an action step on a right that you have. It is a letter. It is called a notice of termination. If you don't have a notice of termination template, again, my program, the Happily Ever After program, does have that in there. It'll walk you through how to customize that, but if you have one yourself, you're welcome to use that. Now, when it comes to a notice, we have to take an extra step than what we did with the amendment. See, with the amendment, both parties agreed, both parties signed. A notice of termination is only one party telling the other party. So, how do we make that legally effective if both parties aren't signing? And that's where this step of notice requirements comes into play. Notice requirements are required under the contract. And what it is it prevents the other side from saying, I didn't get your notice. I didn't know that. Nobody told me that. Oh, you sent that? That went to my junk box. Or, oh, that got lost in the mail. It prevents that. It instead says if you follow these steps, it is considered delivered and received by the other party no matter what actually happened, which is why it's important to follow it. Because when you follow it, you get that like legal affirmation. You are affirmatively taking the right action. Therefore, it is deemed to have correctly occurred, even if there is an error on the other side. And that's what's great about it. The notice requirements are going to be listed in your NDA. Sometimes the section is just called notice. Or there might be a sentence that says the parties will give notice by. You're looking for the keyword notice. Now, if your NDA is silent on it, because that does happen about 30% of the time, you then just simply need to send it via like signature, certified mail, something where you're going to get that signature confirmation that you can show at court or whomever you might need to demonstrate to. I sent it on this date to this address. It was received on this date and address by this person. Right? So something along that. That could be UPS, FedEx, DHL, USPS. Doesn't matter, but you need more than just the tracking number. You need the confirmation of who got it on the other side. And you'll send it to whatever address is listed for that company or party in your NDA. Usually at the top, usually in the very beginning, you're like, this NDA is between party A at this address and party B at this address. Send it to that address. So that is how you do notice. And notice is merely the process that you go through to make sure it is properly sent and delivered to the other side so that you get the confirmation legally under the contract. The other side does in fact know you're terminating it, and they now have to take the steps that might be required in your NDA. And this is what brings us to the next question mark here. You'll notice I put a question mark next to certificate of return. Because now that we have effectively given notice that you're terminating the NDA, it doesn't end there. A lot of times there are continuing obligations. In fact, there's almost guaranteed to be continuing obligations. It's just which obligations are triggered for which party. It's possible you even have obligations as the person who is terminating. So, first and foremost is what are the trigger obligations and what are your options? So, a very common trigger obligation is the requirement to certify and return. Okay, let me see if I can share my screen again. Suddenly it went away, my ability to share my screen. Okay, so we're going to go here again, sharing. We're going to back out and share. So, right back to the second one we had here, we have a series of things that come after it. Oh, wow, look at this. Okay, so we've terminated by giving that written notice. However, for confidential information that qualifies as a trade secret, such rights and obligations will survive. Okay, survive. What that means is that anything that falls into the survival category, sometimes an NDA will list, hey, sections 5, 8, and 12 survive. meaning those things that even though the document's terminated, those rights still continue. Here, what is surviving is trade secrets. Now, trade secrets are one of those areas that will almost always survive the termination or expiration of any NDA, no matter how it ends, because trade secrets are protected under the law. They're protected under the law. So you don't even need the contract to protect a true and actual trade secret. Trade secret is a type of intellectual property, like a copyright or a patent. But it's a little bit different because it's kept secret. And so it is always protected so long as it is a trade secret under the law. So ending the NDA doesn't stop that protection. Okay, so that's our first one, is that we have a continuing right and obligation under the law. And so if it was you sharing your information, your trade secrets, the other side still has to keep them protected. If you have trade secrets of the other side, you still have to keep those protected if that's the way your NDA was set up, right? Who gets what information and who protects it. So, first is trade secrets and any other requirements under the law. For example, copyright. Okay, so if you have a copyright in something, it's still intellectual property. Now, the NDA would prevent that from would no longer prevent it from being shared, but it still doesn't give the other side to copy it, use it, own it, or anything like that. You still have those rights under the law. So a slight shift. They now could share that information, but they cannot use it in a way that violates your intellectual property. When it comes to other information not protected under the law, which, unless it's intellectual property, trade secrets, patents, copyrights, and trademarks, if it doesn't fall into one of those four, there's or a different contract. Let's say you have a contract in place, like a license agreement for your product. If it doesn't fall into one of these five, it is probably no longer protected now that the NDA has expired or been terminated. I'm going to repeat that. If it doesn't fall into one of those five categories of either being intellectual property or protected under another contract with this party, like a customer contract or a vendor contract, it is no longer protected under your NDA. And this is where this next obligation comes into play for a lot of non disclosure agreements. Upon the disclosing party's written request or termination of this agreement, right, we just terminated it, whether that be termination by mutual agreement, termination by expiration, or termination by notice of termination. The recipient and its representative shall promptly return all the information or destroy all of it and provide written certification to the other party that the information has been returned and or destroyed. So merely by this NDA ending, both parties now have to return everything automatically. Everything in their possession now must be returned to its original owner, or they have to destroy it. And destroy comes in not in like you light everything on fire and have this big party to destroy things. But when you think about things being on hard drives and cloud and data systems and things like that now, we destroy the data, we erase it, we do other things to it. We don't really we don't hand them back our hard drive, right? So this idea of return or destroy. So return would normally be things that are physical or tangible, and then you would destroy any of your electronics, is how that would normally be. So this NDA says that you have to do that. It's over. You automatically now have to return or destroy everything, and you have to certify that. That is great. So I'm going to return back to our scene here because we have gone through the three of these, and I'm going to revamp them in a slightly different way. So if you didn't follow, don't worry. I know it could feel like a lot. Continuing obligations post termination. One, there might be things in the NDA itself. Those things you are often required to return or destroy the information immediately. So even though the NDA is over and you have the information, it does not mean you get to keep that information. Now, it's possible the NDA doesn't say this. And if the NDA doesn't say you have to give it back, then you don't have to unless the other side asks for it. It is their information. So if it's in there, you must return or destroy it. And in the NDA sample we just looked at, it also says you must also certify. You must also certify. So that's automatically triggered with a contractual obligation. By terminating the NDA, you must return or destroy, and you have to certify. So what is a certification? Let's go back to this for a sec. And I'm going to show you a certificate of return and destruction, okay? So certificate of return and destruction. Here we go. So here is one. And it is simply a document that one party will send to the other, confirming that they have, in fact, returned and destroyed all the information. They're going to say the date that they destroyed it, and they're going to sign that document. Now, this is one of the templates that you'd get with my Happily Ever After program. That program has every single template, customization guide, and action steps for anything that could happen during your business NDAs, whether that's termination, expiration, return or destruction, and so on. But that is what it is a simple document that one party will sign and not the other, right? So if it's your information that the other party has, you just terminated the NDA. You also want to include the certificate of return and destruction with that notice. Include that certificate of return and destruction within that notice. You do not sign it, they sign it. They are signing that they have confirmed that they no longer have your information, that they returned it or destroyed it, which is great because then now, even though your NDA is not in place, they don't have access to your information. They can't use it. It is not unprotected because it's not in their hands. Does that kind of make sense? When the NDA was in place, it was okay to have it in somebody else's hands because it was protected by that NDA. Without the NDA there, your information could be left unprotected unless you get it back. And what the certification is let's say they lie, right? A certification is kind of like a legal promise. They're not just pinky swearing to you. Oh, yeah, I don't got it anymore. And they're like holding their fingers behind their back. No, pinky swearing, they don't have it, is not enough. You want written, signed confirmation. And that's what that is, because now you can leverage that against them if you ever needed to. But if they've done it right and they're telling the truth, everybody's hands are clean, everyone's good. They now know they don't have to worry either about accidentally anything else. So, continuing obligations after you terminate, those possible obligations of either being required to return it, being required to destroy it, or you want to get that certification of return or destruction. Then we talked about survival terms, terms that survive after it's over. There might be some things that exist after the NDA is over. And I have here an NDA sample that has an example of a okay. So this is the other NDA we had looked at earlier. And this one says under our how to terminate by providing written notice, each party's rights and obligations under this agreement shall survive. So we're looking at that word survive. That's the key word here. Survive is the word that you're looking for because that means it continues living even after the rest of the NDA is over. Any expiration or termination of agreement for a period of 2 years. Okay, so the rights and obligations under this agreement will continue to exist after termination for a period of 2 years from the date of that termination, even after the return of or destruction of confidential information. That's awesome. So it says that even though you've returned and destroyed it, what you're aware of, what might be lingering in your hands, what might still be out there, still is protected for 2 years. So in some ways, it didn't really end the NDA in one way because it's still protecting the information. Your termination just terminated everything else about the NDA. Right, so we've now seen this. The other NDA template didn't have this, but this one does. So it's something to look at because every NDA is going to be a little bit different, but we do see these common themes, right? And then this one also has that the trade secrets under applicable law shall also survive. So this one has both categories. This one has survival of 2 years, but it does not require return or destruction. And it doesn't require the certificate of return and destruction. Where the other one, instead of it surviving, said, hey, you have to return everything and you have to certify. So they're both going to have a very similar impact, but they go about those in two different ways. And then they both protected trade secrets after, because even though it may or may not be said in your NDA, it's a law, right? And you don't want to violate the law. You don't need a contract to say you're going to comply with the law. The law is there. You got to comply with it. So this is an example where you see that survival of those obligations with the option of return and destruction, where the other one says you have to return and destroy and you have to certify, but there is no survival ongoing other than as required by law for a trade secret. So let me stop sharing my screen here and going back to this, right? So those three categories, hopefully by walking through them in those different ways and giving the different examples, you can kind of see how each of them may come up in different ways. Continue. So now that it's over, you're continuing obligations. It may have requirements. Sometimes they're optional. They are. It's up to you whether or not you want to ask for them. The survival terms, which may or may not be there. And then, of course, intellectual property laws and other laws are going to stay in place and active no matter what you do because they are the law. All right. Kind of went into this a little bit. Now that it's over, is it still protected? Because this one comes up a lot. Is your information still protected? You're going to look for that survival clause. That survival clause now puts a countdown on it, right? The one we looked at said 2 years. So the second it hits 2 years, any information still in that party's hands is no longer protected. No longer protected unless there is a law protecting it. Plain and simple. It has a countdown of 2 years. So if you terminate today, 2 years from now, any of that information is fair game. Fair game to be shared, fair game to be used in a different way, fair game. Which is why I always prefer the other side, that certificate of return and destruction. I like to have the affirmative when the NDA ends, it's over, get the information back, and have the other side certify that they have returned and signed it, because now there shouldn't be any questions, no matter whether or not there's a countdown in there. Your information is not in their hands. They have confirmed they don't have it anymore, which I always find the safer route to do. And of course, the one exception to all of that are if there are laws in business, the two main areas are the intellectual property laws. That's a trade secret law, patent law, copyright law, and trademark. If you're in the United States, that's the way those are broken down, those four. Or if you have another contract, right? If your product's in their hands still under a customer contract or a vendor contract or some other signed document that affects that, it's still protected under those. But if that doesn't exist, that information is fair game unless you have a survival clause or certificate of return and destruction. So really important to make sure you have those done. So let's just take a quick step back at the action steps. We went through a lot there. First and foremost, you're going to select the method of termination you want to use. Do you want to actively terminate it one side to the other? Do you want it to naturally expire? Expiration is where it just goes its term. Everything is good and it's ended. Like if you have a 2-year NDA, after 2 years, it's over. Or you can terminate it by mutual consent. And then you're going to want to create the document that goes to whichever method you've chosen. If you're doing mutual consent, you have the amendment and both parties will sign it. Or if you're doing the termination, write that notice of termination where one party terminates and does not need the other side's permission, consent, or signature. You're going to want to send the notice of termination. Then you're going to solidify that document. Right? If you're using the amendment, that is done by both parties signing it. By both parties signing it, it's now legally effective. There's that. But if you're sending that notice of termination, because the other party is not signing it, The other party can disagree with you. They can do it. It doesn't matter. You have the right to terminate by giving that written notice. You are terminating by giving written notice. You want to make sure you have properly given those notice through those mailing requirements. Like I said, if it's not listed in your NDA, if it is in your NDA, look for the word notice and see if it says anything. And there's usually anywhere from 1 to 3 options listed in a typical NDA. And then, of course, now that it's over, do you want that certification of return or destruction? Some NDAs, it's automatically required upon termination. Others, it's an option. So choose that if you do want to send that, get that template and include it in your amendments or your notice letter. And then confirm if you have any other ongoing obligations. Is somebody required under law? Is any of the stuff protected under law? If it's not, you want it returned or destroyed. And if not, you want to see if there's a survival clause and maybe there's just a countdown. And the countdown really isn't the end of the world for a majority of confidential information. An example is like your marketing plan or your pricing. Okay, after 2 years, nobody cares what your pricing and marketing was 2 years ago. It's not that big of a deal because you've either abandoned it or you've already put it into action by now, but that doesn't mean that it may not have value. So it's one of those that majority of information does lose its value in time, but you never really know depending on what else they have or what other information they have with it. Now, I did tell you all I was going to give you this big resource on where you can find any of these. So I have a program called NDA Happily Ever After, and it is all the templates, all the action steps you need for your business NDAs. So it's going to set you up with an NDA and tell you how to get that into place. If you ever need to amend or change that, it's going to give you all the templates, walk you through step by step, customization guide, everything so you can get it done very quickly and out the door. If you ever have a termination or expiration situation, because we've talked about how those obligations can be varied a little bit differently for each of them, it's going to give you all those documents, a notice of expiration, notice of termination, certificate of return and destruction. All of that is in there. And it's even going to give you all the stuff you might need if you ever have a threatened or actual breach of your NDA and you need help recovering. It's going to walk you through that as well. And you can find that right on my website, CEOLegalcoach.com/happily ever after. And that's where you'll find all that information. Now it is time for the Q&A. I know you guys are going to have some on this one. I know you are. So go ahead and start getting those into the chat and let me see what we got here. Can I cancel if the other side has breached? Okay, so if somebody's breached your NDA, well, we looked at for a second there, let's go with 2 things. One, why would you want to terminate it? The NDA is what is giving you protection. The NDA is what giving you protection with the breach. If you didn't have the NDA in place, you have nothing protecting you. You have no way to take legal action. You have no way to recover. So first and foremost, because somebody has breached, I actually would never recommend terminating that NDA because that's what's giving you your protection. But as we looked at before, the NDA will say if and when somebody can give termination notice. In both examples we looked at today, they both simply said by giving notice at any point in time. It didn't require a triggering event. It didn't say, hey, not till after 2 years, or hey, not until someone's breached. Those things. So as long as you have the right to terminate, it doesn't matter why you've chosen to terminate. That does not matter in majority of times. Both examples we looked at, it just said you can terminate. You don't have to explain to the other side why you want to terminate. So breach, convenience, just don't want to do business with them anymore. All of it are good reasons as long as you have the right to terminate, follow the steps for termination. But if breach is the reason you want to terminate, I would actually advise not doing that. Of course, every scenario is a little bit different, but the NDA is what's protecting you. Why would you want to remove that protection? Yeah. Now I can say that, yeah, I see your note. I see your note. What if I just don't want them to have my information anymore or I don't want to share with them anymore? That's cool. Absolutely. So an NDA, while it is meant to protect information should it be shared, it's not an actual obligation to share. Nobody says, I will in fact give you documents A, B, C, and D, or I will in fact give you all this whole list of information. That's never a requirement in an NDA. An NDA is simply, I won't share or misuse it if I get it, right? So it's a little bit different. So even though the whole point of it is to protect information if shared, there's no affirmative requirement to in fact share. So you don't have to share if you never want to. You don't have to share to the extent that you may ever want to. And if someone's breaching or doing something, well, you can stop sharing with them. So you can keep the NDA active and in place and just stop sharing. Because the active NDA is the protection, not the requirement to share. So you do not ever have to share if you don't want to under an NDA. Totally optional. hmm Yep. Uh, Mine doesn't have a termination clause. What can I do? Okay. It is possible that your NDA just doesn't say anything about termination. It's silent on the whole matter. You got two options. So we went through the three options, right? Mutual consent. That one does apply. You can do that because that's not an affirmative one-sided termination. That's both parties agreeing. As long as both parties agree, that's cool. So you always have that option. The other side is on board. Everyone can terminate. Not a problem. You're going to use an NDA. And then the other one is letting it expire. Just letting it expire naturally. If it's up in 6 months, let it go up to 6 months. Because I just said under the breach part, you don't have to share. You don't have to share with the other side. And you don't have to terminate to stop sharing. Just stop sharing. There's no obligation. You're not breaching a contract by not sharing information. So if you want to end it and you can't, either see if they'll get on board with it or to just wait it out. Wait it, stop sharing and wait it out for it to naturally expire and get your information back. Also check if there's, like we saw in one of the NDAs we looked at today, one said that you can ask for the certificate of return and destruction at any time. So maybe you ask for that, that the NDA stays active, but that you can affirmatively ask for a return and destroy, which means they have to return and destroy what they have at that point in time. So it keeps the NDA in place, but as long as it's a right you have to do that, you can trigger that right as well. So lots of ways to feel and practically have the same thing as termination without actually having to terminate in the event your NDA doesn't allow you to terminate when or how you'd like. Yeah, great questions, guys. Okay. What are the risks of canceling an NDA? Yeah, if you want to terminate, what are the risks? Kind of like what I said earlier. If your information's out there without an NDA or some other contract or law protecting it, your information is out there unprotected. And that could be use, that could be sharing, that could be monetizing it, and so on. So I would be mindful of when you're terminating, you are removing the protection. Find another way to get your information protected, returned or destroyed to you, a survival clause, or making sure that there is a law in place or another contract in place to protect it before that NDA is over. Because confidential information, which is what an NDA protects, confidential information under the law is information that is not public, meaning you have not shared it with anyone, even your mom. So by making it shared, aka public, because you've given it to one other person, without an NDA, it is no longer confidential under the law. You need an NDA or some terms of an agreement of some sort or a law protecting it. Otherwise, you're waiving it, you're letting it go. And by you being the one canceling it, you're effectively saying, I'm okay with it not being protected because you're the one making that choice. So if you make the choice to remove the protection, you're also making the choice to leave your information out there unprotected. So being mindful of that. Yeah. If you guys have any other questions, don't forget you can always put them in the comments below. And of course, reach me at my website, CEOLegalcoach.com. This has been Acacia, the CEO Legal Coach.